Good afternoon. My name is Ellen Vos and I'm co-director of the Maastricht Center for European Law. And I would like to welcome you all to this 12th lecture of the series on European environmental law that is organized by Marjan Peeters in the context of the Green Deal network. I'm very privileged to announce the speaker of today. That is actually Marjan herself, in fact, and Professor Marjan Peeters is a professor of environmental policy and law and holds the chair here since 2008. And I don't have actually to further introduce you to her because she is a renowned expert in the field of environmental law. And we're always very happy to hear her insights on the various topics on environmental law. And today she will talk about the EU emissions trading instrument, an instrument that she knows very well because she has studied it from the very beginning, in fact, that the instrument was introduced. So without further ado, I would like to ask Marjan to come forward and to then start with her presentation on to fall in love with the EU emissions trading instrument. With a question mark. Thank you very much.
Thank you very much for these kind words, Alan, and welcome to the on-site participants, welcome dear students, and also welcome to the online participants. Yes, I can imagine that you have wondered, why does she put forward such a title? How can one ever fall in love with a legal instrument? Well, I will explain that in a second to you why I have developed this title. But I also would like to convey with you that I will provide an answer to this question by the end of the lecture. And this lecture intends to explain to you the contents of this market-based regulatory instrument. And I also will provide a critical reflection to that. And perhaps by the end of this lecture, you yourself have a kind of an answer to this question. I look forward to hear about that. And here is the reason why I came up with this title, because this was a statement done in the hearing of Commissioner at that time designate Mr. Wopke Hoekstra, now Commissioner for Climate Action with the European Commission. And in the hearing in which he had to convince the members of the European Parliament that he should get support for acting as a commissioner, he made this confession. And you can watch this indeed in this recorded video. He said, I have a confession to make. I am actually in love with the EU ETS. And moreover, he stated, it is the crown jewel and working horse of the whole package of EU climate law. Well, let me then explain first about this EU emissions trading instrument. Why is this instrument so attractive? Well, first, let's say that this EU ETS, that is the abbreviation we commonly use, this European Union emissions trading scheme, which applies to greenhouse gas emissions, is indeed a core regulatory instrument of the EU climate law package to implement the EU-wide emission reduction targets that are codified in the European climate law, such as the net 55% emission reduction to be achieved by 2030. A regulatory instrument is applicable to major power plants and industries, more than 10,000 installations across the European Union, and to aviation emissions within the EU. So if you take a flight from Brussels to Rome, for instance, or to Athens, it is covered by the EU ETS. There is a total emission limit put on the allowable amount of emissions. So there's an absolute cap on what emissions are allowed for the entities under the emissions trading instrument. And the students of European environmental law already know this. This gradually declines. This is put into the law, and it will ultimately lead to zero greenhouse gas emissions under this instrument if it remains untouched by the legislator. Let's see what will happen. This allowable number of emissions under the cap is distributed by means of quota. We call them allowances in EU law, and they can be acquired by the emitters by, inter alia, for example, an auction. I will come back later to the allocation methods. And the allowances can be traded. That can, for instance, happen in case of a sudden low demand for products. There's a drop in the economy, or if a new emission reduction technology is invented, then an industry perhaps has too many allowances, and the industry can sell its surplus allowances to another industry that is in need of allowances, perhaps because of an increase of demand for its products. Actually, well, a brief observation about how we call this instrument. We usually say EU ETS, EU Emissions Trading Instrument, but this is not the best name. It puts a lot of emphasis on trading, but that's not the primary reason why we have this instrument. Cap and trade is a much better expression because it puts at the first place the cap. This is what we want in environmental law. We want to contain emissions to achieve the objectives from the treaty, high level of environmental protection. So the cap is truly important, and the trading is a secondary characteristic of this instrument. So cap and trade is what it is, to cap emissions and the possibility to trade as far as there are allowances available. Let's delve in the theory of emissions trading, cap and trade. And it's so wonderful that the idea has already a long history. It was published in a tiny book, a small book, published in 1968 by Mr. Dales. And in this book, Pollution, Property and Prices, he developed this idea of cap and trade. And in theory, the design of emissions trading is simple. 4 main elements, these 4 steps. First, the government sets this cap on pollution that I also just have mentioned, and that is the maximum amount of pollution. Moreover, the amount of pollution can be lowered over the years by strengthening the cap. The cap is then divided into quota, the allowances, which, according to the proposal from Mr. Dales, have to be bought by the polluters. That is an application of the polluter pays principle, a principle codified in the TFEU Article 191. So the polluters have to pay if they want to have an allowance in order to emit. The quota can then be traded among the polluters to reach efficient reductions. That is where the economists have contributed a lot of literature on, so on the efficiency of the instruments, such as in this book from Mr. Teitelberg, an economist, an expert on emissions trading. If you are interested in economic literature, there's plenty. So the idea that by this trading, reductions will be achieved at there where it is at lowest cost is the whole economic rationale behind this trading option. So the cap and the trade, and then the 4th element, polluters, emitters may only pollute if they surrender emissions quota equal to their emissions. Otherwise, they must be penalized. And that's the backbone of the system, of course, in order to make it environmentally effective. Only with enforcing this rule, we have a trustworthy approach in terms of environmental effectiveness. So in this way, with this instrument, this is the theoretical proposal, an effective and efficient reduction of emissions can be achieved. The question is, however, how to put this into practice, and that is what the European Union has done. With the Directive 2003/87 from October 2003, the European Union has started a big legislative experiment because there was no experience with cap and trade, emissions trading in the European Union. There were some experiences in other jurisdictions, notably the United States, but nothing in the European Union. And of course, when you start an experiment, you have to learn, you have to evaluate whether it works. And the instrument was not perfect in its first design, perhaps also because of political compromises. And we have seen many legislative amendments, improvements to say so, in order to make the instrument better. These many legislative amendments have resulted in a, I must say, very complex legal instrument with detailed rules and a lot of technical case law, but also some fundamental core decisions. I will come back to these fundamental core decisions later. Now under the Green Deal, which is a policy communication by the Commission, but it has resulted in many updated and new environmental laws. And under this Green Deal, the EU ETS has been upheld and broadened. So it has become even more important in EU environmental law. It gets a wider scope and a stronger environmental ambition. I will explain that to you as well. And I would also like to observe that this cap and trade, this regulatory instrument with a trading function, fits in a way to the market thinking we see in the European Union with the internal market. So it fits in a way to the EU culture. And of course, that is also open to debate on how to use market forces for environmental protection. But it fits in a way to what the European Union is. Then a few slides about the regulatory design and the development is learning by doing. And what's important to see that the Emissions Trading Directive from 2003 started off with a decentralized model. Member states were able, they had the power to decide on the allocation of the allowances. And you see here a picture of the cement industry south of Maastricht, the NC. Still with smoke coming from the smokestack, so it was still operating. It does not operate nowadays anymore, but it was the Dutch government who had the competence to decide how many allowances such big industries, such important economic actors for the national economy could get. The directive also obliged the member states not to ask any money for the allowances, but there was an obligation to give away these allowances for free. That is perhaps done in order to get the instrument accepted so that we could start with it. It stands, of course, in stark contrast with the polluter pays principle, and I can already say it has now been abandoned, this rule of 90% free allocation. Well, in this first phase, many disputes emerged between the European Commission and various member states on the too generous national allocation. So the national governments wanted to be kind to their national industries, so gave away many allowances. The European Commission disapproved national allocation plans, and that went up to court procedures, etc. But this struggle, this legal battle, also resulted in an awareness that we should not proceed with this decentralized model in the European Union. So an amendment was adopted in 2009, and that led towards centralized allocation. And this is the first major reform of the directive, which led to centralization, but also differentiation. Centralization, because the national allocation plans were abandoned, more power was put at EU level, and interestingly, instead of national allocation plans, an EU-wide cap was introduced, gradually declining. And the European Commission got huge powers to set harmonized rules for the auctioning and for free allocation, and the member states only have to strictly execute, so hardly any discretion for member states. Also in this reform, there was an increase of auctioning and even an obligatory auctioning for electricity production. So we moved from free allocation to obligatory auctioning for electricity production, and for other industries, a gradual increase of auctioning over the years, except for a very specific category, that is the so-called carbon leakage sector, which is about the international competing industries, so industries that compete with industries in third countries. And if in the third countries there are less intensive greenhouse gas emission reduction regulations, the European industries would lose competitive position. So therefore, the carbon leakage sector, major industries, steel, for instance, still got the allowances for free. In terms of environmental effectiveness, the cap was there. So giving away allowances for free did not harm the environmental integrity of the scheme. And there was a widening of the scope and inclusion of new industries and 2 other greenhouse gases. So centralization, differentiation in terms of allocation, different categories there. And something else happened. The scope of the EU ETS at that time was expanded to aviation. However, aviation also got a differentiated approach because aviation was not put under a declining cap. So aviation emissions were under a stable cap, which is more generous for this sector. So a kind of a protection measure for aviation. That's a political decision from the legislator to treat aviation emissions in such a way. Then we saw 9 years later a second major reform that happened in 2018. This second major reform entailed a strengthening of the decrease of the cap, so more environmental ambition. And that was done to align the EU ETS with the new 2030 target at that time of 40% emission reduction by 2030. Next to this new environmental ambition, a very specific mechanism was introduced that we have discussed in the tutorials as well this week, the Market Stability Reserve Mechanism, for a very complicated economic instrument, but its basic function is to take away a surplus of allowances. So if there are too many allowances in the market because they are not used by the operators, it could mean that they will be used later years. And in order to avoid an increase of emissions over time, the Market Stability Reserve Mechanism, according to set criteria in a decision from the Council and the Parliament, takes away these allowances from the market. So it's also a mechanism that helps the environmental ambition of the instrument. So we really saw with this reform a strengthening of the environmental ambition of the instrument. And now we have the third reform, the Green Deal reform. I already have shared with you that the role of the ETS has become even more important in this reform. And let me go through 7 reform elements here. The first one is again a strengthening of the cap, a view of a new target for 2030. So first we had a target of 40% emission reduction, but because of the need to take more ambitious action as codified in the European climate law, which is a regulation, the EU ETS had to be aligned to this new target. And here also we see an interesting differentiation. It is actually the case that the EU ETS aims to contribute 62% emissions reduction by 2030. Other sectors not covered by the EU ETS, think of agriculture, have a less intensive emission reduction target. So you immediately see some differentiation among different emitters, where the EU ETS contributes the highest share to the emission reduction target. So again, a strengthening of the cap, and the EU ETS has the most intensive emission reduction effort. Obligation to say so even. Second, aviation emissions within the EU are now also under a declining cap. So there's also a strengthening for aviation emissions. And also aviation was also protected in a way by getting many allowances for free, but that will be phased out. So there will be full auctioning applicable to aviation emissions from 2026 onwards. So if things go well, that will be translated into the ticket price of a flight when you take a flight. Third one, there's an obligation now, and that's quite a revolutionary turn in the EU ETS, an obligation for member states regarding to what they spent the revenues of the auction. Auctioning is now the preferred method, so there will be revenues with the government, and the revenues go largely to the member states. But until this reform, the member states were free to decide about the revenues. And in the Netherlands, for instance, the revenues went to the general budget. That's not possible anymore. There's still quite some discretion if you read about the aims to which the spending has to go, but it is now marked, and there needs to be reporting by member states on how they spent the revenues from the auction. Then, fourth point, there's even now a new ETS called ETS 2. It is in the same directive, but it is just its different emissions trading system than for industries and aviation. And this ETS 2 applies to transport other than aviation and maritime, to housing, and to certain small industries. So the scope of the ETS is expanded to households, public transport, car transport, etc. And that is really a very important enlargement of the instrument. Then the fifth point is, and that's connected to this ETS 2, a social climate fund is established for addressing social needs following the pricing of fuel for transport and housing. So prices will go up, and that can lead to problems with households. We also have the concept of energy poverty that has to be taken care of. So the social climate fund that also gets revenues from the auctioning is also established. And then the sixth reform element is that maritime transport will be under the scope of the EU ETS. Aviation was already under the scope of the EU ETS, but maritime transport will now also be under the ETS. Even also extraterritorial emissions. So if a ship sails from a port in a third country and it sails to a port of an EU member state, then 50% of the emissions that this ship causes have to be surrendered by means of allowances. And this is an extraterritorial application of the ETS. It of course applies also to ships sailing from a port in one EU member state to a port in the other EU member state. But this is also truly a new element of the ETS with its own specific rules. And then also very important, last but not least, CBAM, Carbon Border Adjustment Mechanism. That means that a price will be put on the imported goods that are produced in third countries with greenhouse gas emissions. And that is, of course, also to ensure a more equal competition with industries in the EU. And this is such an innovative and new instrument, of course, also with many legal questions, that we will dedicate another lecture to that. And that will be delivered on the 25th of April by Stefan Wijzer. Well, so a large reform, a strengthening, increasing ambition, a lot to discuss. Let me recap already a little bit this regulatory developments. We see a largely centralized model, as I just have explained, but there is one very important element dimension that I have not yet explained and that we also have discussed this week in the tutorials, and that is how to control this instrument. And so to control the compliance behavior of the emitters. And this is largely in the hands of the EU member states, as is very common in EU environmental law. So in inspection and enforcement in EU environmental law is really still in the power of the member states, no real powers there at EU level. Let us review the specific provisions here. And first step is that industries have to develop a monitoring plan that has to be approved by the national authorities in order to have a correct account of emissions in an annual emission report that the emitters have to deliver. And this emissions report is crucial because that emissions report determines how many allowances an industry, an emitter, has to surrender. And of course, it's crucial that this emissions report is correct. that it reflects the real emissions of a whole year by an emitter. And the EU legislator has made provisions that verifiers, private actors, have to check the emissions reports before allowances can be surrendered by the emitters. It's an obligation for the emitters to surrender allowances, but they can only do so after the check by the verifier. A Commission regulation applies to how these verifiers have to verify, but furthermore, these verifiers are contracted by the emitters themselves. So it's a kind of a market-based control of the behavior of the emitters. The compliance with the public law provisions is sourced out in a way to private actors. Member states are ultimately responsible, of course, for the correct functioning of the EU ETS and for their control and enforcement. And they have the obligation, member states, to impose a fixed financial penalty in case an emitter did not surrender a correct amount of allowances. So this is very special. It's unique in EU environmental law that the directive prescribes a specific sanction that has to be imposed. No discretion there for the member states. And I will come back to case law later on this issue. And ultimately, hence, as I already said, issues with reporting and verification have to be discovered by the national authorities. This is the backbone for the environmental integrity of the scheme. And here the question is, what happens in practice? How trustworthy is the system? How great is the compliance with the rule to cover your emissions by surrendering allowances? I will also come back to that with an example from practice, from case law at the national level. This is just for your reference, just to get an impression of the many changes. So it was a learning by doing. In a way, I find it very impressive how at the highest level the EU legislator was able to keep on amending and reforming the instrument towards a better design. I am not arguing that this is the best model we have, but we can see this progress in the decision making. But this has also resulted in very complex legislation. It's not easy to understand the instrument. Moreover, these are only the directives and decisions adopted by the Parliament and the Council, and there are many implementing and delegated acts in order to make the system work. And moreover, it's still experimental. We have seen with the latest reform many new provisions, also on maritime emissions, for instance. And there will also be legal questions on the application of these new provisions, the ETS2 for the maritime emissions, the extraterritorial function, etc. Still an experiment. I am not sure how much you are already attracted, whether you feel attracted now by this instrument, already get emotional about that. I'm not sure. I have now only talked about the regulatory design. I will now move to the courts. Perhaps you like that even more. Let's see. When we go to the role of the courts, to the litigation, I would like to start with this statement by Kati Kulevesi and co-authors in an article where they have stated that the majority of climate law-based lawsuits have concerned the implementation of the Emissions Trading Directive. And we have a lot of strategic climate litigation, sometimes called Holy Grail litigation. They get a lot of attention, rightly so, in media, etc. But we have a lot of litigation. The majority is about this emissions trading instrument. A lot of litigation has happened. And still more study has to be done. Also, for instance, studying why are there much fewer cases with regard to another important instrument, the Industrial Emissions Directive, also very important. Why do we have only a few cases there compared to the EU ETS? What are the strategies behind? What does trigger these claims? Well, second bullet point, what is very visible is that many industries went to court, and particularly against the scope of the directive, but also the allocation. So there was really, in my view, a wave of litigation coming from industries in order to address the decisions, for instance, on how many allowances they got. And this led to really many references for plenary ruling to the Court of Justice of the EU, often on legal technical matters, very complicated cases to read on a very technical benchmark issue for allocation, for instance. So that is one striking development, or perhaps not striking, it perhaps also shows that the EU ETS means something for the industries. There is a reason to go to court. Of course, ultimately, they have to pay. We have an absence of litigation by environmental organizations. I find that also striking. What could be, so there is not yet a preliminary ruling on a claim started by an ENGO with a national court. What are the reasons for that? Well, a legal reason could be that we don't have a provision in the EU ETS directive enabling access to justice in environmental matters, so no provision for ENGOs to go to court. What we now increasingly see, like in the new air quality directive, there will be a provision on access to justice for ENGOs, but we don't have that in the EU ETS and was not introduced with this third reform. So if in the national system there is not a good opportunity to go to court, then of course we don't see cases started by ENGOs. But in some jurisdictions we do have these opportunities. So there could have been cases. Perhaps there's a low interest from the ENGOs. I'm not sure why. We should do more interviews. Or perhaps there exists quite some confidence. Like the American ENGOs, like the Environmental Defense Fund, they really also published about the emissions trading and why it should be applied. So yeah, according to the facts, no real ENGO litigation against the EU ETS. I also have explained that the environmental ambition is strengthened over time. So there could also be some, confidence in the instruments. Although I would say that on the compliance cycle, we would need the NGOs to function as a watchdog. So the general conclusion is that the EU ETS stands. The environmental effectiveness is not weakened by the court procedures. And I can give you two examples of more fundamental cases. The first example is the extraterritorial reach of the EU ETS. What happened? Well, in the expansion to the aviation emissions in 2009, also extraterritorial emissions were included. What does that mean? Well, that means if you then took a flight from Brussels to Beijing or to New York or to Cape Town, the emissions of that whole flight were covered by the EU ETS. So the air operators had to surrender emissions also for the extraterritorial part of the flight. This went up to the Court of Justice with a request for a plenary ruling, and a court case started by American air operators with an UK court. But according to the Court of Justice, there was no legal problem with this extraterritorial reach of the EU ETS. It was not against any principle or any international treaty or whatever. So the extraterritorial reach of the EU ETS was confirmed by the Court of Justice. Later, however, this extraterritorial reach was abandoned by the EU legislator. Why? Because massive international protest, political protest emerged against this unilateral measure from the EU legislator. So until now, this extraterritorial reach is not part anymore of the EU ETS because of this political protest and the political decision of the EU legislator. But from a legal perspective, it was okay. Another example of a fundamental case is the so-called Arcelor claim, steel industry, big steel industry, against the, at that time, limited scope of the EU ETS. So Arcelor was under the EU ETS, but other industries like chemical industries, and they compete with chemical industries on the market, for instance, for products to build cars. And Arcelor found or held that this limited scope, and they were covered, was in breach of the principle of equal treatment. They even tried to get the directive annulled for that reason, but here the Court of Justice found no breach. So the Court of Justice even said that it is okay if the legislator takes a step-by-step approach and gradually broadens the scope, which actually has happened now with the EU ETS. With regard to litigation, there's a very interesting development, which means that part of the EU ETS will, the jurisdiction will move to the general court. And that is the consequence of a reform of the statute of the Court of Justice, where indeed preliminary rulings will be delivered as soon as this becomes formal. There's now a deal, I believe, on this, an agreement on the content of this reform. There's a provisional agreement indeed. And then the General Court will take questions on the EU ETS, unless it are questions of principle, like those that involve interpretation of the treaties or the Charter of Fundamental Rights. And here, of course, the question emerges, what are then questions of principle? And also given the fact that we have now many new provisions, it will be interesting to see what the legal problems, questions will be. Well, when I review the EU ETS case law thus far, and there are many, many, many decisions, we can, I think, distinguish already 5 categories of fundamental questions. Perhaps they are questions of principle, like questions on access to environmental information. It's almost a kind of a human right to have the environmental procedural right to have access to environmental information under the EU ETS. Equal treatment, as I just have explained, the Arcelor case, so that was also on the principle of equal treatment. Then the third category is the extraterritorial reach of the EU ETS. As I also have explained, aviation will now be put again under an international scheme of emissions trading, to put it like that. It's called CORSIA. But maritime will also have this extraterritorial reach. Will there be again questions? We can have questions on the allocation and cancellation of allowances, perhaps principles of good administration, perhaps even the right of property in case of cancellation of allowances, if that would happen. And then finally, the 5th category is enforcement with the principle of proportionality. And that is where I would like to focus a bit more on. Because what did the EU legislator do with enforcement? And that is to introduce a strict penalty regime. So if an industry does not surrender, or another emitter does not surrender sufficient allowances, then the member state has to impose this financial penalty, a fixed excess emissions penalty. It is very strictly prescribed by Article 16 of the EU ETS. I already shared with you that this is a unique provision. The penalty has to be imposed. There was a Swedish industry that actually, in a way, made an administrative mistake and did not surrender in time its allowances. And the financial penalty was imposed on the industry, and the Swedish industry went to court arguing that this was against the principle of proportionality. And the Swedish court sent a request for a preliminary ruling. Here, interestingly, the Advocate General pointed at proportionality. It was clear from the facts that the industry had sufficient allowances in its account, but they forgot, to put it like that, to submit them before the deadline to the government to surrender the allowances. Here, the Court of Justice did not follow the opinion of the Advocate General, but upheld the very strict approach as chosen by the EU legislator, also in order to avoid any further, let me say, problems if there would be more discretion for member states, because we really have to remember that we really have to remember that the EU ETS applies on big economic actors which are crucial for a national economy. So there could be the attempt of member states to be protective to the industries with lower penalties. So here this integrity to say so is upheld by a strict penalty. But then we had another case of a sugar industry, Nordzucker, a German industry, where insufficient allowances were surrendered, but this was not detected by the verifier. It was a bit a complicated case in the sense of it's not always that easy to understand what exactly is covered by the EU ETS and what not. So there could have been some confusion there, also perhaps with the verifier. But the verifier said, well, the emissions report is okay. But later the national authority said it's not okay. More allowances had to be surrendered. Also, a financial penalty was imposed. And here the German court asked the Court of Justice of the EU whether here also the strict penalty had to be applied. And here the court agreed with an exemption in case, particularly if the verifier has approved the report, then the penalty can be fine-tuned by the national authority according to the circumstances of the case. So in principle, a rigid enforcement regime, but in certain circumstances, as in the case of Nordzucker, a more fine-tuned enforcement can take place. And of course, it will be super interesting to do further research what actually happens in practice. I understood this week from one of the students that in France, 49 companies have not got a financial penalty imposed while not surrendering sufficient allowances, and we need to examine that further. So compliance with the EU ETS is crucial. And the real question is, are emissions correctly monitored, reported, and verified? And what do we really know? Well, according to the European Commission, this is from a report from 2022. Well, let me read it out. They hold, despite the difficult economic situation due to the COVID-19 crisis affecting the 2020 and 21 compliance cycles, the level of compliance with the EU ETS remained consistently very high. Operators responsible for over 99% of emissions from stationary installations in aviation in most years met their legal obligations. So a very positive statement on how trustworthy the instrument is. And of course, it's very delicate here to question this. I think research-wise, it is important to question what do we really know. And I only can give some illustrative examples, like this case from the Dutch Administrative Court from August 2018. I saw this case in which a financial penalty was imposed on a big EU ETS installation in the Netherlands. And the reason for the imposition of this financial penalty was an incomplete emission report. 2.5% of the total emissions was not included. Perhaps your immediate reaction is, that's only 2.5%, but it was really a super big industry. And I did some calculations in the case note, but the profit was more than 1 million euro, assuming an emissions price of 20 euro. So that's quite a big amount of money. In this situation, the incorrect emission reporting, so a mistake with the emissions report, was not identified by the verifier. So the verifier approved the report. So the industry could surrender emissions, but that was could surrender the allowances, but there were not enough allowances to cover all the real emissions. The Dutch Emissions Authority identified the mistake and hence imposed this financial penalty. So this is an example where we see a big industry, and we can, I think, assume that the big industries that they have hired expert staff to manage this, that perhaps it was a mistake. I don't know what has happened, but that there were not enough allowances surrendered. So this became visible because it was detected by the administrative authority. But I'm not sure, and this is something my methods fall short as a scholar to do further research, it is not known, I think, and difficult to research in how many cases such a shortfall in the reporting is not detected. And one of the master students from last year who wrote a thesis on European climate law brought to my attention this announcement from the European Public Prosecutor's Office, which is an announcement about a probe into possible fraud regarding the EU emissions trading system. I checked again today. There's no further news to this announcement for February 2023, but this is an example of where it was found necessary to start a criminal investigation towards possible non-compliance. So I only can give you these two examples, plus the example I got this week from one of the students with an article in Le Monde, where a French journalist have pointed at the non-imposition of financial penalties. Okay, I already come to rounding off a few final slides. An appreciation of the EU cap and trade approach. First is, it is a detailed legislative framework. It's really a challenge to understand it and hence also to apply it. There are many complex provisions and differentiated approaches towards sectors. So that is a challenge for us all, also for those who work with it in practice. And in addition to the directive, there are many new and updated Commission decisions. And of course, all these provisions can lead to legal battles, etc., and all needs to be applied and interpreted. So for me, it's no problem to break the taboo and to admit that even while working for many years on the instrument, it is still a challenge also for me to understand the provisions, let alone to predict or to understand how does it really work. And that relates to the second point at the slide. How does the EU ETS deliver? Because in environmental law, it's very instrumental. We want to have the right protection of the environment. Well, as we have seen, the environmental aim of the ETS is not weakened by litigation, and the legislator has strengthened the gap, so that seems to go in the good direction. Is this a success story of EU environmental law? Well, that depends on the compliance. The compliance is key, and I'm not sure, but the question is there a black box? And if there is a black box, what's in it? Question mark. I also would like to make a forward look because the instrument is here to stay and actually it will kill itself because the cap will at a certain moment be 0. So then there are no allowances anymore. I'm confident that learning by doing will stay, also in light of the many new provisions. First forward look is a question about the litigation. How much litigation will happen? Will the wave of litigation continue? Will there be a new wave with the new provisions? What will happen there? We also see challenges from Poland against the emission directive itself, the amendment of the original directive, but also a challenge against the market stability reserve mechanism decision, and Poland holds that too many allowances are put in the MSR. That is a challenge, and let's see what this will lead to. So we already have cases there. Second bullet point, the forward look should not come as a surprise to you. My question is, will it be possible and better possible to identify non-compliance and to rectify unlawful emissions? Because if there is non-compliance, it is of course important that there will be a rectification so that allowances will still be surrendered. And then a third observation, which is a bit more complicated one. But as such, the EU ETS is a strong instrument with a codified cap. It will lead to less emission allowances. But it can lead to indirect negative effects on the environment. So if we steer strong to reduce greenhouse gas emissions, it means that we all have to move to alternatives, like more renewable energy, because fossil fuel will be phased out. But renewable energy does not come without problems. We have big concerns about the biodiversity effects of wind turbines. So how will this be addressed? We have a strong steering instrument for putting down the emissions, phasing it out, the greenhouse gas emissions. But to what will that lead? Also, a discussion about nuclear energy is popping up. Environmentalists struggle with nuclear energy, many difficult questions also on waste and on the risk. So what we need here is, of course, more an overall integrative vision, an overall integrative approach. We have one strong steering instrument. We could be positive about that, but we need to keep an eye on what that means for other aspects of the environment in order to reach an overall high level of environmental protection and not only be successful with climate change. And then finally, we will see increasing scarcity because of the lowering cap. And what will be the reaction in society if prices will skyrocket, if we will have very high prices because of the scarcity? How will social and economic effects be addressed? What will be the reaction by industry, by aviation operators? Will the EU ETS stand then as well? Or will there be intervention into the instruments by the EU legislator? Or will there be huge non-compliance? What will happen then? And there is already one paper, I have the link here on my slide, that tries to think through what will happen with this decreasing cap when there are no allowances anymore. They also refer to the strategic behavior of industries. Perhaps industries will try to massively bank allowances, to buy now allowances in order to have sufficient allowances for in times of scarcity. That will trigger the market stability reserve mechanism because there will be many allowances in the market, so there will be less allowances for the auction. So there can be a kind of a dynamic by strategic behavior by industries to take well care of their own economic position, but that can lead to problems in the whole market. So with that speculation, that forward look, I'm going to end my lecture, but I still need to answer this question. I'm not sure whether you've already feel attracted to the instrument, whether you fell in love with the EU ETS. What could be our message to Mr. Hoekstra? What is my personal message? Well, it's a bit a different answer, not about falling in love with the EU ETS, but perhaps very obviously from my side, I would advise please fall in love with the environment and try to find the best regulatory approaches possible in order to address the environmental problems. Thank you very much.